and get the rest of the committee in here as they drift in. Everybody's pretty busy these days with all sorts of stuff going on. We are continuing the hearing on Senate Bill 279 today. We've got testimony coming our way from actually neutral testimony. Let me find my sheet here. I had it somewhere. Thank you. First, let me have ask our reviser, Matt Sterling, to give us another quick bill brief and overview, and then we'll get going. Matt? Is Matt there?
One moment, Mr. Chairman. I'm going to pull that back up.
Okay, thank you, sir.
All right, thank you, Mr. Chairman, and good afternoon, committee. Kind of as a refresher, Senate Bill 279 would require a developer of a wind generation facility to enter into a facility agreement to comply with certain setback requirements and to have an application approved by the Board of County Commissioners where the proposed project was located. For the setback requirements, it requires 1.5 miles from a residential property or public building, 3 miles from any airport, federal wildlife refuge, public hunting area, or public park, and 1 mile from any property line of a non-participating property. There's a number of requirements as part of an application to the Board of County Commissioners that the bill would require the developer to submit. If there's a notice requirement that the board would be required to hold a public hearing on an application at least 20 days, but no more than 90 days after the publication of the notice of the application. Section 4 of the bill provides the details of that required facility agreement that a developer would have to enter into with a landowner. And then Section 5 concerning leases or easements involving wind resources for generation of electricity would amend current law to void a lease or easement if it doesn't commence within 5 years after being entered into, and also provides the property owner a method of terminating the lease or easement. And I'd be happy to try to answer questions.
Questions, committee? I do have one, Matt, on page 1, line 33, where it talks about facility means an electric generation facility consisting of one or more wind turbines and accessory structures and buildings. Does that, when we're talking about transmission lines, are we talking about the transmission lines just from the generating facility to the grid, or all transmission lines? We had a question about that.
So there's 2 parts of that definition that I would focus on. One, the definition facility means an electric generation facility consisting of 1 or more wind turbines, and then the remaining portion of that definition is a modifier of that generation facility consisting of turbines. So the reference in there to transmission lines is still tied back to that to those wind turbines. Secondly, I would note that in that definition, it's talking about a facility that, the facility is located within the boundaries of the land where a developer plans to construct all or a portion of that electric generation facility. So we're talking about within the property where the facility is going to be located and a transmission line associated with that generation facility.
I think I understand. So in other words, between facility and the grid, any transmission lines there, correct?
So if located on the property where the facility is being developed.
Okay, I think that clarifies it. Thank you, sir. Any other questions, committee? Seeing none, we'll move on. Yesterday we didn't have time for neutral testimony. We do have one neutral conferee, and that is Jacqueline Augustine. And just identify yourself for the committee and welcome.
Thank you. I'm Dr. Jackie Augustine. I earned a PhD from biology from Kansas State University. I recently accepted the position as Executive Director for Audubon of Kansas. Audubon of Kansas is a nonprofit environmental organization that represents 4,500 members, mostly within the state of Kansas. We are the voice of wildlife and wildlands in Kansas. I'm providing neutral testimony today because there's no provisions in this bill for wildlife with the exception of one line. And so so being the voice of wildlife, we cannot support this bill because the voice of wildlife is not in this bill. However, we are also not proponents because we understand that landowners who want to preserve wildlife on their land, this will give them a means to fight industrial wind. And so we have a neutral position. What we're advocating for is that the governor's Tallgrass Heartland Wind Moratorium, which has received bipartisan support, be added to the bill, and that it include a moratorium on all Flint Hills counties, or all counties that have part of the Flint Hills in them. This will protect the wonderful tallgrass prairie resource and the wildlife in that. We also think that the guidelines, there's numerous guidelines for Kansas, including the Wind Energy Siting Handbook, Guidelines and Options for Kansas Cities and Counties by the Kansas Energy Council, the Site Wind Right maps produced by the Nature Conservancy, and the Kansas Department of Wildlife Parks and Tourism Wind Power Guidelines. All these guidelines suggest that wildlife should be considered when siting wind turbines. The Wind Energy Siting Handbook also considers cultural and historical things that are of value to all Kansans. And so because this is a state issue, and I think those resources are valuable to all citizens in the state, that they should be considered. And then I have one more kind of specific comment on it. The provision, the SB 279, says that there should be one public hearing for industrial wind, and I think this is underestimate of the number of hearings that are required. And for background, my previous position, I was the president of the Council of Ohio Audubon chapters. And one of the chapters within our jurisdiction had an industrial solar complex coming in. They met with the public, and at their first meeting, they had a map that outlined the region that they wanted to put the solar industrial power plant in. They listened to the feedback from local constituents, and then the second and third public hearings, they proposed a modified map, which took into account landowner requirements and suggestions. And I think this level of transparency and this level of collaboration with industrial wind and local peoples has not been the norm in Kansas. So we would encourage that. Thank you.
Committee, any questions? I do have one. Do you have an estimate of how many birds and bats are killed by these things every year?
I do not have an estimate, but they are concerned, and that's why we are really concerned about the proper siting of these things, because that is a significant cause of mortality.
Senator Francisco.
Thank you, Mr. Chair. A follow-up to that. Would it be more helpful or less helpful for the turbines to be placed close together or farther apart to help protect birds?
So so in order to prevent or reduce collisions with turbines, you want to put them in a small space as possible. If they're widely spaced throughout the landscape, there's going to be, as birds migrate north or south, there's going to be more opportunities. And so most wildlife views suggest that you should put turbines closely together and that they're not surrounded by habitat that would draw them in. So putting them into developed habitat close together is better than having them spread out over native habitat that wouldn't draw them in.
Any other questions? Marshall County, we had this come up yesterday. Parts of Marshall County are considered to be in the Flint Hills. Would you consider that to be the case?
Yes, I would too. I actually was invited up by the Marshall County residents, and I went and visited southern Marshall County, and the hills are indicative of the Flint Hills landscape. There is a little bit more agriculture than other parts in the Flint Hills, but there's still a predominant amount of native vegetation. And the presence of prairie chickens, they showed me videos that were taken on the property and showed me the area where those were taken. The presence of prairie chickens usually indicates a high quality habitat, and prairie chickens can benefit from moderate amounts of agriculture. And so that habitat supports prairie chickens, has a wonderful native landscape. So I would include it in the moratorium. And that example particularly, not only does it have unplowed prairie, it also has a unique geological feature, the Twin Mounds. It has historical features in remnants of the Oregon Trails. And it has another geological feature. It has this spring that just has bounteous water that's been used by settlers for a long time. And I think, using the guidelines that I stated before, any one of those should have convinced industrial wind to move somewhere else, and that was not the case in Marshall County.
Senator Bowers?
Thank you, Mr. Chairman. Thank you for being here, and sorry I didn't have a chance to meet with you in person, but I've heard about a box of the Flint Hills. Is Marshall County in this box, in this map that I've seen? Thank you.
Marshall County is not in the Governor's Tallgrass Heartland Wind Moratorium, so it's not in the box.
Any other questions? Seeing none, thank you very much. We'll move on now to opponent testimony, and up first is Kimberly Svaty. Kimberly, state your name and...
Okay. Good afternoon, Mr. Chairman and members of the committee. My name is Kimberly Svaty, and I appreciate the opportunity to be here. And it is in deference that I am here opposing Senate Bill 279. I know we have a lot of conferees, and so I will be brief because I do think we have some solid technical expertise as well. But regarding this bill, the bill was crafted in a vacuum without any input from the industry that it seeks to regulate. And so there are problems with the bill, private property rights issues, there's a lot of legal ramifications, and just kind of a lack of understanding about how wind farms are actually developed, sited, and permitted across the state. So my name is Kimberly Svaty. I do represent the renewable energy industry, the Kansas Advanced Power Alliance, and you can see on my testimony a listing of the companies that are part of our organization. I won't go through there. Most of the largest energy developers in the United States are part of our organization, including companies like Tradewind Energy, which started in Lenexa, Kansas, at two guys literally in a car, and they built themselves into one of the largest wind developers in the United States. They have offices in Lenexa, Kansas, and they went from two guys to 150 people employed in that facility, which I think is in near Senator Warren's and Senator Gossage's district. So we do stand in strong opposition to Senate Bill 279. The evolution of the industry, I think it's important to understand that we first came into being in 2001 in the state, and from that time frame, when it comes to siting and just generally how we do business in the state, there has been a significant evolution as it relates to how wind farms are sited. So we do have the siting guideline handbook. We also have, which was referenced earlier from the Kansas Energy Council, we have a large other handbook associated with siting. We have the Kansas Department of Wildlife, Parks, and Tourism guidelines. We have the Site Wind Right guidelines from the Nature Conservancy, and also the Wind and Wildlife Initiative, which is the national organization that provides very detailed information related to how wind farms should and shouldn't be sited across the United States, but also in Kansas. But we also have counties that have their ability to zone in or zone out or to issue bans, of which that has been upheld by the Kansas Supreme Court. Wabunsee County was the first county in the state to say, we actually don't want commercial wind in our county, and so they instituted a ban in 2005. There was a local landowner that did sue the county on private property rights issues, and the Kansas Supreme Court 5 years later reaffirmed the right of Wabunsee County to do in fact what it did. And the industry has always stood by that. So when McPherson County instituted a ban, the industry stood by. We pulled out of McPherson County, Sedgwick County, Anderson County. Linn County actually put it to the vote of the people on the November 2020 ballot, and it passed. That's completely fine with the industry. The industry is not going to go where it is not welcome. We need 3 things when siting a wind farm. You need willing landowners. You need a community that is, the vast majority of the people in the community want the project. You have to have good wind and access to transmission. So I think that's a really important point. When it comes to the Flint Hills box, I was not fully involved in crafting the initial Flint Hills box, which you can look at my testimony, and I do have a map of the Flint Hills box, and so I would just urge you to look at it. That initial Flint Hills box in 2005 was crafted, and I can't speak to how it was crafted, but in 2011, when it was expanded, it was largely expanded at the using data information from the U.S. Department of Fish and Wildlife Service, and it relates to the Tallgrass Heartland Legacy Conservation Area. So this was the area where there was the most native intact prairie. It was also the area where there was the most native prairie chicken habitat. And so you can absolutely see from this map exactly how the Audubon Society, which was part of the agreement, Tallgrass Ranchers, the Nature Conservancy, Kansas Department of Wildlife Parks and Tourism, as well as several other landowners were all involved in creating this new map. So I do think that that's very important. To that end, we actually have counties on the southern border of the box that are pleading to have their opportunity to build a wind farm. And unfortunately, they're not getting the answer that they want to get, which is that the wind industry won't come there because of the Tallgrass Heartland, which is honestly no different than what was discussed yesterday in Marshall County, where we know residents of Marshall, there are some residents of Marshall County that want the box extended. And so there are people on both sides that want the Tallgrass Heartland box to look a little bit different. And there are plenty of people in the box that would like to have access to their private property rights again. So my testimony, this is a very long and complicated bill. I'd be more than happy to speak to the various components of how wind farms are sited. It's a multi-year process. There are public meetings. There's always the willing landowners that have to sign on the dotted line for their contracts. My testimony does provide the timeline of how projects are sited, and it goes into detail on the various elements of siting. To that end, there is so much to unpack, and we don't have time. But my testimony does speak to the specifics related to the lighting mechanisms and FAA requirements on those lighting mechanisms, and that the FAA is responsible for approving whatever lighting mechanisms are used on every single turbine within the state. That's not something that's at the discretion of the developer. It's actually determined by the FAA. So my testimony does speak to that. My testimony speaks to decibel levels and sound, which this would be the only industry in the state of Kansas that would have any sort of decibel regulation requirement. Certainly there is no requirement on combines or railroads or lawnmowers or things of that sort. So, that's something to consider. The setback process, I've got information here, decommissioning. So lots of different policies that we can talk about. But I think it's important for everyone on this committee to understand, in its totality, this bill would be the most restrictive bill in the entire country. And which is ironic because Kansas, depending on the time of year with Iowa, we're either the first, the #1 producer of renewable energy or the #2 producer of renewable energy. We go back and forth. And the other thing this bill does is it creates and puts in statutes mandates on technology that is already, it's either not approved or it might be antiquated, and it doesn't allow flexibility for new technologies to be adapted and to be used, and we do feel that that's a problem. And I specifically mentioned that in the discussion about the decibel levels and wind screens. I would like for you all to turn at the back of my testimony to really understand a key portion of this. This is another map. This is the setback requirement map. There was a piece of legislation in 2019, House Bill 2273, that has all of the setback requirements that included in this bill. And so as you can see, this is what the state of Kansas would look like from a development standpoint. Green would be areas where you could develop. Black is areas where you could not develop. And that is what the state would look like from a development standpoint if Senate Bill 279 were to move forward. I also want to show you all, also in the back of your testimony, when we're talking about the setback requirements. This is Ash Creek Township, where my husband and I own and operate our farm. And so if you had, per this bill, if you had a landowner that was new to the community and decided that they wanted to put a park in to their, a 10 by 10 foot pocket park like we have down on Topeka Boulevard, and they decided that they didn't want a commercial wind farm. So here's their 10 by 10 pocket park. And per the setback requirements, they would either be controlling what happens on 4,521 acres or potentially up to 18,000 acres. Well, that individual doesn't own 18,000 acres or 4,500 acres. They may only own 5. But that is a complete usurpation, not only of local control, but of those landowners' private property rights per the way the bill is written. So lastly, I don't speak in hyperbole when I say that this piece of legislation ends the renewable energy industry in the state of Kansas. I would like to reference to the testimony included of several of the developers in the state, where they speak to this bill would be kill a job-creating industry that has invested billions in the rural part of the state. They talk about the grossly excessive, devoid of any supportive or safety or scientific basis siting restrictions. Or in the case of NG, which is a large developer as well, it's an affront on the rights of rural landowners to freely and reasonably use their property to diversify their income by participating in wind projects. It talks about the role of the counties. And then also from RWE, which is a large developer in the state, it's a complete forfeiture of Kansas's role in our domestic energy future. So when you have companies like BlackRock and JP Morgan Chase, which just announced yesterday $150 billion in investment in renewables in the country in the next several years, we are talking about losing out on that. So yes, as an industry, we have developed a significant amount in the state, and this may be a postmortem on how much has been invested, but what is really at stake is all of the additional billions of dollars that could be developed in our state going forward. And companies, hedge funds, investment institutions all have the opportunity to choose where they're going to put their dollars. And Senate Bill 279 is a really strong signal that Kansas is probably not going to be the best place for you to do that. And to be sure, Oklahoma, Colorado, Nebraska, Missouri, Iowa will stand and applaud because they will gladly take this money. So with that, I'm more than happy to answer any questions about all of the technical details in this bill at the appropriate time. Thank you.
Thank you. Next up, Alan Anderson.
Chairman Thompson, committee members, I want to thank you also for the time today. I know we have a lot of people that do want to speak, so I'll try to get to the point. And the first part that was mentioned is there should be no mistake about what this bill does. It does end renewable energy, wind energy development in the state of Kansas, period. And as alluded to, what that means isn't that wind energy development stops. It will go to our neighboring competitive counties, states. Oklahoma would be glad to see it, Nebraska, all the different states we compete with for these projects and the economic benefits. What this bill does do then is it takes the property rights from all the citizens of Kansas who want to participate in these projects, and it takes the natural resource away and their ability to use that, and it takes it by the state. That's an economic principle we generally don't see a lot in Kansas because that's what this would be. And as also mentioned, we don't at this point have to guess what happens in the state of Kansas. We have 20 years of operating projects, 40 utility scale projects in 30 counties that have hosted projects. So I'm going to go through a little bit of why it works that way and how that's been successful in Kansas. First, we have to talk about property rights. And we get this confused a lot, and it's a difficult topic. But property rights are how a person utilizes their personal or their property in commerce, how they use their property. What you heard other times, and you certainly heard yesterday, was how I stop someone else from using their property rights. And we'll talk about the process for doing that. It is certainly not in a bill like this. But what we're saying here is you cannot use your property as you see fit, and we're not going to go through the process. But what we heard yesterday is I want to talk about how I stop you from using your property rights. Professor Alkian at UCLA, who's now since deceased, but he had one of the great kind of quotes on this. And he said, one of the most fundamental requirements of capitalist economic system And one of the most misunderstood concepts is a strong system of property rights. And that's what we're talking about here, is an assault on the ability for someone to use their property to enter into commerce. That is the capitalist system. Instead, we're asking the state to take that right away. You can imagine that's the exact opposite of a capitalist system. So how do we know that property rights are important? Well, we contain property right protections in the U.S. Constitution and the Kansas Constitution. In the U.S. Constitution, in the 14th Amendment, we say, no state shall deprive any person of life, liberty, or property without the due process of law. In the state of Kansas, in Section 18 of the Bill of Rights, we say all persons for injuries suffered in person, reputation, or property shall have a remedy by due course of law. The key here is that we have a due process system. And that's remarkably important here. And if you think it's taking place here, I really would question that. If you can go through that bill and you can go through the sound restrictions or the setback restrictions and have full comprehension to that, and you think that is adequate for removing a property right and the natural resource from all Kansas citizens, I would say, think about that again if that's actual due process. I don't think it is. So how do we do it? So how have we done it all this time in the state of Kansas? We have 100 years of zoning laws and that process. Well, we do it through a balanced system, and we have the Kansas Home Rule statute to start with. And what that says is the Board of County Commissioners may transact all county business and perform all powers of local legislation and administration it deems appropriate. And the Kansas Supreme Court reinforced this when it said, home rule powers are to be liberally construed for the purpose of giving the counties the largest measure of self-government. And even though we go down to the local authority on these issues, we make them go through a significant process so that we give due process. Because again, any restriction we put on personal property is a taking of that property. And that's okay because there are reasons to do that, but we require the process to ensure that the fairness is given. So if we go down to the county, they go through a zoning process. They have to have a planning commission that then creates a comprehensive plan that looks at the land uses of that county for their citizens, and they make a determination of uses they want to see furthered and those they would like to see not attracted. They go through, create zoning regulations that go through a process that are public and allowed to get participation from the local community. They go through an entire public process to do that. And that's because when we address land use at the local level, it gives the authority to the people who are most close to the location. So they know the wants and needs of their community as opposed to coming here from Topeka or Johnson County telling people in Ford County what they should be doing. That's somewhat abhorrent to how we usually do things in this regard. So the Zoning Enabling Act gives us that balance of property rights, because we do restrict property rights on many occasions, and there's good reason to do so, but we require the due process. It is certainly not a situation like this where we sit here today and we're going to tell the entire state how they can do it in their local communities. And again, this system works. It protects the property rights in a way that has worked for 100 years, of which this bill turns on its face. We also have to understand that sometimes people aren't happy with the process. They go to their county commissioners and they say, here's my position on this issue. And the county commissioners have a chance to take that in. They don't always agree. I think any legislative body can certainly appreciate that. There's probably no decision you have made where everyone said, I agree, and there's no people who are dissatisfied with it. The same thing happens here. And so you'll see people that are dissatisfied with the process or with the result. And that's okay. What we have to make sure is the process works, and in Kansas it has for 20 years. I also want to mention something on unzoned counties. That is a choice. It is a policy decision by a county, and many counties are very excited to be under a situation where the county allows its residents to make the determination of how their property rights are used. They don't make a choice between land uses, and in that case, it's made by the individuals as opposed to the county. That's not a condition that falls upon them. It is a choice in those counties. Last point I'll make, and please read the testimony. There are many of other failings within the statute that would be, put it bluntly, not quite legally sound. But this bill also violates another tenet principle to capitalism, and that is the freedom to contract. We were fortunate enough to have a legal professor, David Pierce, who was one of the preeminent property law and oil and gas professors in Kansas. And what he said on the freedom of contract is, freedom of contract is the foundation of the American economy and our capitalist society. Here, this bill is telling people with farms and ranches, you are not sophisticated enough to enter into agreements that you see fit for your property. As Professor Pierce has stated, that is abhorrent to our capitalist system and also something that generally in Kansas we have not welcomed. There's many other items that please, if you get a chance to read the testimony that I've submitted, I think you'll see some others. And again, I'm happy to answer questions later as well.
Thank you. Because this does cover a lot of legal ground, and I want it fresh in the minds of the committee, I would like to open it up to questions at this point for anybody who would like to ask any questions, committee. Senator Olson?
Kimberly, couple questions. We negotiated the Senate Bill 91. I think a lot of the committee doesn't realize now there's a 10-year property tax exemption. Is that correct? And we're probably just 3 or 4 years away from certain counties getting a lot of property tax. Is that correct?
That is, Kimberly Svaty with the Kansas Advanced Power Alliance. And yes, in 2015, we moved to a 10-year property tax exemption. Those projects do come on the property tax rolls at that time. All during that 10 years, though, the industry is paying a payment in lieu of taxes as well. Many of those projects, though, will be coming on the tax rolls soon.
Yeah, and now they're all the same, right? Is wind, nuclear, coal, hydro, whatever, all has the same exemption.
Nuclear is treated differently, but all other forms of electric generation now are treated the same. Yes, Senator.
I'll save my questions for later.
Okay, thank you.
Senator Bowers?
Thank you, Mr. Chairman. This was Mr. Anderson, if you can pop up. We've heard because counties aren't zoned, this is why wind farms will look at them. Can you tell us the behind the scenes, what has to happen before you pick a county zoned or unzoned that you, first of all, if it's not zoned properly, you wouldn't be there. But then are you looking at state agency input, federal agency? What are you looking for?
Right, and one thing I did, I forgot to introduce myself. Okay, I'm Alan Anderson with the Polson LA Law Firm, a vice chair of the Energy Practice Group. I'm also adjunct professor of law at University of Kansas Law School, so I forgot to give that introduction earlier. So there's a myriad of factors that a developer will go through, and it really comes down to the items referenced. We have to have willing participants, we have to have a resource, including transmission, and then you eventually have to have someone who will offtake the power, so that can come into place on location. Being in a zone county or a non-zone county is really not the material fact within that. And I get the pleasure of working on most of the projects in Kansas. And in reality, it can be easier, frankly, to work through a process in a zone county because they have a process in place. So it's a little smoother. In unzoned counties, there's a little more of a process because we always work with the counties. There's never been a situation where something's been pushed through with an unzoned county. So there's no selection of a location based on it being zoned or unzoned. It's just not a factor as far as that perspective.
I have a couple questions. You talked about home rule. 19-101A says counties shall be subject to all acts of the legislature which apply uniformly to all counties. Counties' home rule is statutory. Cities is constitutional. So applying a uniform law across the state to protect landowners who may not want one of these turbines near their property, we have every right to do that as a state legislature, correct?
There's two factors here, and your question even alludes to the policy problem with the question, but the state can amend the Kansas Home Rule Act to add things that are uniform across the state. That is true. It would still be subject to a due process challenge related to whether it qualifies under that. So at least implicates these other items. Secondarily, what you just referenced there is the policy problem. We have an issue that allows the counties to choose how they want to locate wind projects. Ford County is a great example. Ford County has 6 wind projects. They did the first project, it went well. Did a second, it went great. Went third, fourth, fifth, and sixth project, it went great. And now they have more coming Should Ford County or any of its citizens didn't want projects, they would have been able to stop it by then. But what this bill is saying, so as a policy matter, is total affront to our 100 years of the process of how we allow counties to have the decision related to that, and it takes it away from counties that want projects. Yesterday, what you didn't hear from were county commissioners. The county commissioners have been satisfied with this process. You will have some people that are dissatisfied, but by the question, what you have is the problem with the bill itself. It's saying if someone doesn't like a result of their county commission, they go to the state on a one-off basis and ask for relief as a minority position in their county.
We heard testimony yesterday about the city of Corning, and you talked about local control and them making the decisions, and yet you put pressure on the city of Corning. You took city council people aside one by one or in groups that would avoid the Open Records and Open Meetings Act and put pressure on them to stop the zoning of the extraterritorial zoning for the city of Corning. So would you consider that a free and fair process in influencing them to make their own decisions about local control?
Yeah, I'd say yesterday, as your question alludes to, there is also missing most of the information as it relates to Corning. So when we talk about pressure, offering to be a partner with the city, if that's deemed pressure for participation, then I think that kind of misses the point of what it is to be a partner with the county. What also wasn't referenced yesterday, Corning had an election. There were people that were not favorable to the project for a period of time. The city of Corning had an election and new people were put in place that were more favorable. No one mentioned that, but that's the recourse we have in a democratic republic is if we don't like decisions that are made, they can be replaced. And that happened in the city of Corning. We have a new mayor in the city of Corning that was more interested in wind energy. That wasn't referenced yesterday. That was the difference. So when we talk about this process working, another great example is the city of Corning. And they're also, I think, quite happy with the results of the financial benefit.
And we talk about community and landowner support. We also heard a lot of testimony, and I've been in some of these communities around the state where there are public meetings and you get 200, 300, 400 people showing up advocating against the wind turbines being in those areas because of the safety and health concerns. And yet those county commissioners vote against the will of those people in that county, and they're not being listened to. Again, when these are, and these are unzoned counties, where all of a sudden they're realizing a need to be zoned, and the wind companies come in very quickly. They swoop in, they give these folks very little time to organize any opposition or to talk to the county commissioners. Again, where's the due process for them?
Well, first of all, completely say that's not how the process goes. It's a years-long process. And what often happens is people don't like the decision, so they say, I'm not being heard. That's not the case. And in the cases I know you're referencing, because I worked on those projects, even if a couple hundred people show up a meeting, that is not the majority of the county. And in a democratic republic, unless we're going to get rid of a democracy, we have recourse. If the county commissioners are not taking the action that their constituents think is, important, they'll be replaced. In those cases, they absolutely were listened to, but in the marketplace of ideas, sometimes they don't think that their ideas win, and that's what happens, and certainly happens in that case. So ultimately, counties do move forward. We are fortunate to have fantastic people in these counties. If you look at Nemaha County and Marshall County, the ones you're referencing, fantastic county commissioners that are doing what they think is best for the county, listening to commissioners throughout the constituents throughout the county. And yes, there'll be some that aren't for it, but it's not because they're not being listened to. In the marketplace of ideas, they're just not winning the day. And that's okay, but they have to understand that it's not because they're not being listened to.
I've also heard about landowners who've been threatened to be sued if they wouldn't sign leases.
That makes no sense to me at all. I've never heard that. So if that's being said, then I think if they've got an issue with that, they should bring it forth to their county commissioners or whoever they should do, but that doesn't make sense to me.
How many lawsuits are you engaged in on behalf of NextEra against cities and counties?
And this is another great example, is Reno County. We have a litigation there. Talk to the Reno County commissioners that were in place there. Talk to the county councilor that was in place there. That is not an antagonistic situation. It is a point, just like it comes up, we had a disagreement on a point of law. 2 commissioners were actually in favor of the project, we need to remember, as it relates to Reno County. There was a question on the protest petitions, whether they were valid under the law. We have the right, and we coordinated with the county to say we're going to move this forward to have a court decide. I would ask you, talk to the county councilor in Reno County and see if that's some kind of antagonistic situation. It's a point of law that we thought both needed to be resolved. I mean, we have a county courthouse in every county so that we can have a orderly process to have points of law resolved. That shouldn't be deemed as a negative, and in those counties, it's not.
How many lawsuits?
I'm thinking offhand, that's the only one that we have is Reno County.
It's Reno County right now. One last question, then we'll get back to testimony. With regard to, pardon me, public nuisance, landowners who decide to sign leases are also potentially subject to tort liability for public nuisance. And public nuisance can include stray voltage, aesthetic damage, ice throws, interference with electromagnetic fields. That includes TV and radio signals, death of birds and bats, adverse health impacts on adjacent landowners. Where does the property rights of the adjacent non-participating landowners end and the participating landowners begin? For example, if you've got a public nuisance, say you decide out on your land in an unzoned county, you want to put out a shooting range, and bullets happen to cross that property line onto an adjacent property. That's public nuisance. That's potential tort liability for that landowner. Do they not have a duty to mitigate adverse situations? In other words, in this case, we're talking about shadow flicker, sound. A new Finnish study, study out of Finland just came out that said infrasound and low frequency sound can travel 9 miles. That's quite a distance. Gage County, Nebraska set a 1 mile radius limit on turbines, the same we're talking about in this bill. Does the wind company not intend? We're talking on the Kansas siting guide, only 500 feet. Turbines fall apart. They disintegrate. Parts of those turbines can fly 3,000 feet. Ice throws, Apex did a study about 3,200 feet. Ice throws. Does not the wind turbine company have a duty to mitigate the potential public nuisance and protect those landowners who may sign these leases and may not be aware of their tort liability?
So the good news is every wind project is absolutely sited in accordance with all the safety protocols necessary for those, including what you're talking about. So if you look at the setback distances from the equipment manufacturers, who are some of the greatest engineering companies in the world. You have GE, one of the great engineering companies in the world. Their setback distance is 1.1 times the height of the turbine. That's what projects are cited in Kansas, at least, usually further than that. So the answer is, I can find you a place like Gage County, Nebraska, just like you tell your kids, just because someone else did something wrong doesn't mean you should do it. Just because Gage County, Nebraska did something doesn't make it a good decision. It's the same thing here. Doing a mile is absurd, and if they want to do that, and we'll take all their wind projects and make the revenue from that, great. But the wind project, every one of them is absolutely cited safe. We have 20 years history, and that's just in Kansas, yet alone the rest of the country. They're absolutely cited safe in every one of the ways that they could be.
Any other questions, committee? Thank you. Next up, we have Jack Tiemeyer from Kingman County. WebEx. Jack, are you there? Apparently he's not there. Let's move on to Patrick. What's that? Oh. Jack, you're muted. Could you unmute your mic? There we go.
Yep, can you hear me now?
Yes, we can.
Can you hear me now?
Yes, we can.
Okay, sorry about that. I was having a little trouble getting it turned on, but yes, this is Jack Timish, 8-year House Representative and now a County Commissioner, newly sworn in. We actually have 3 wind farms in our county, which were put in the last 10 years probably. So we've got Flat Ridge 1, Flat Ridge 2, next era, and then there's one being built now. So, and then possibility of another one. We've had a lot of these conversations and I went to the meetings as a House representative, sat in on them and listened to both sides of the argument. And as a farmer myself and owning land, you know, I was one to say that I'm glad I had the opportunity to lease my land and pad my retirement. You know, as a farmer, we don't have capers. When I started buying land with my wife 42 years ago, the idea of our land was we'd be able to rent it out. If we got an oil well, we'd have that income. And then wind towers come along, which was another shot in the arm. So, you know, some of the things that you talked about with ice off the wings, these companies, they shut them down. They shut them down when the wind's blowing too hard. They shut them down when they ice up. So, you know, our connections with the wind farms that we've have now have been good. You know, the roads they put in and stuff, we're able to use them to access our pastures or our farm ground. They haven't restricted us from that kind of opportunities. You know, there's always negative to everything, you know, and when you talk about sound, I got one that's within so far of my farmhouse. And when the irrigation engine's running 1.5 miles away, I can hear it, but I do not hear the wind tower. When the oil well's pumping on my neighbors that's 2 miles away, I can hear that, but I won't hear my wind tower. So, you know, when it comes to sound, you know, my tractor makes way more noise when I'm sitting in the cab, you know. So some of the things that they're touching on, and this setback deal, that would absolutely take, you know, Kingman County out of the picture. And for us, we signed a letter and sent it up there. And I called the other 2 commissioners because they've been there longer than I have. And I said, what do you guys think? And they said, no, leave our local control alone. We can work with our people. Yeah, we're not going to make everybody happy and somebody's going to be mad. But as of right now, we're moving forward with more wind farms. And if we didn't have that, you know, I can tell you that with the money that they received off it, they built a new $5 million jail. They refaced an expo center in the city there that everybody rents, welcome to use. We are now in the process of taking that money and along with federal money, we are going to put in 5 new bridges that have needed work. And without this revenue and this income, with the way the oil field is and even some of the commodity, without the revenue from this wind farm, we would not be doing any of this. We are also looking into overlaying some roads with the money from the wind farms. And we are doing it in a way where we are committing that money to the roads for the next 3 or 4 years without raising property tax on any of our people in our county. And that needs to be said. That doesn't get out enough and isn't told to everyone. People would not be so obstruct to these wind towers if the money is used in the right way and if it's there to develop and make our county better. So, you know, I don't want to speak a long time, but I would sure answer questions as a county commissioner if you have any. Thank you.
Any questions?
Any questions?
Sounds like a parrot.
Sounds like a parrot.
I do.
I do.
Could you mute your mic while I'm asking the question? Okay, there we go. Does the county get payment in lieu of taxes or actual property taxes? And unmute your mic to answer.
Yeah, we get a pilot payment on this one that's being in the works right now. When they flip the switch on here the end of April, we will get a payment of 1.2 million. And then we get a pilot payment every year after that. And I can't tell you that exact number on that one. I know one of our bigger ones, I think, is $800,000 a year. And then, like I say, we've got 4 and we're working on the 5th one.
What's the population density of Kingman County? How many people are out there?
Well, when I was in the House, you got to have 20,000, and I had part of Reno and a little bit of Rice County, not very much, and all of Kingman County. So, you know, I should know, but I'm not going to guess at it. I'm sorry about that.
Okay. All righty. Thank you, sir. Any other questions from the committee? All righty. I think we're probably going to have time for one more conferee. Patrick Hoffman.
Thank you, committee. I know we're getting close on time. My name is Patrick Hoffman. I'm an attorney in Ellsworth, Kansas. My law firm is a 4-person law firm, Sherman, Hoffman & Hoffman. And it's transactional practice. It's real estate planning based. I meet with real ag producers. My clients wear Carhartts into the office. It's real mom and pop ag stuff, and it's great. And I'm here today because we have a couple of wind farms. We have 2 built ones in Ellsworth County and Lincoln County, and one that's in development or that has been leased. And so I have represented dozens of landowners locally, hundreds, and then as a part of that, through word of mouth, we've grown to represent hundreds of people across the state in the process of from getting a wind lease in the mail to make up to the point where they decide whether or not they're going to sign the thing. And so what I do and what I've been doing for the last 10 years is really just go through people. It's kitchen table type stuff. It's filling up gyms and talking and answering questions from town halls and explaining to them what's in the lease, what's not in the lease, what they need to be aware of if they sign a wind farm lease, and how it's going to affect their land. And based on the other testimony I've heard today, if I can leave you with one thought and one concept, I just want to make sure you understand that ag producers in Kansas take their land rights incredibly seriously, and they do not sign them away quickly or thoughtlessly. If I have a client and I do a document for that client, and they will read every word in it while they're on the tractor, and they will email me to correct the punctuation. And it's the same thing with these wind leases. They are poring over them. They are aware of them. When they think of their land, they are thinking of multiple generations. It is not just sign this for a quick buck. That is absolutely not what's going on. And it's been a wonderful process to help people do. So I'm glad to be here and answering questions for you guys today because I do a little bit of public speaking, and this environment makes me a little nervous. They would be terrified. Now, I also represent some local government. And I think I'd second everything that's been discussed about counties having the ability to really, just as the landowners know their land, our county governments, they know where the good areas are for wind development and where they're not. They do a good job, and they have the tools to make those decisions, and they make them well, or else if they're not reflecting the will of the community, they get replaced, just like all of us. I also work with economic development in Ellsworth County. We haven't talked a lot about the economics of these things, but just one way I explained it to somebody, we fought like crazy in Ellsworth County for years to get a Sonic. A Sonic is about $1 million investment. Wind farm's a $300 million investment. There just are not industries out there that want to put that kind of money into rural Kansas right now. There's nothing else that will provide the jobs, the pilot, the infrastructure, and then pay the landowners. The wind farms locally gave $30,000 to our fire department in the city of Ellsworth. We can't replace that with anything else. That's taxpayer relief. That helped me on my taxes, and that benefited the community. So they're good stuff. So I'm bogging down in my thought points. I think a lot of things have been covered today, but I'd like to answer questions if you guys have them. Wind farm, I live in a community, like I said, it's transactional practice. I represent generations of people. I have not heard complaints from the residents that live among these wind towers. And I would know. I'd hear it at the coffee shop and the co-op if these were causing problems for people. And they're just not. They're just not.
Any questions?
Uh,
Senator
this
Olson?
is just a comment to you, Mr. Chairman. I think we got maybe one or two members in the audience come a long ways that might want to say something. So if you could, I think a former Senate president maybe have something to say.
Yeah, we only have probably a couple more minutes. We have to be on the floor. Thank you. Any other questions for Mr. Hoffman? So should we jump ahead to, well, David Kerr, yeah.
Thank you, Mr. Chairman and members of the committee. I am Dave Kerr and from Hutchinson. After I left the Senate, I got involved with Hutchinson-Reno County Economic Development, and as a result, I had the privilege of welcoming Siemens Wind team that came to Hutchinson in 2008 in May. We were one of 13 communities being looked at that point, and those 13 had been culled from over 100 that had responded to a request for proposals to put Siemens' new North American wind nacelle facility in there. So we had a good meeting with them. They left, went to the other 13 cities in September during the state fair. They came back with the whole 8-person team. It happened to be Governor's Day at the fair, so we had the governor meet with them, and the governor said, you know, we've got great wind in Kansas, and we really want to develop that, and we're very strong on renewable energy. We welcome you. So they left, went to the other 4 finalists, and finally, we got the phone call. They were going to tell us whether or not we were the winners of the new facility. And they told us, look, we really like Hutch, but the community in second place, Sioux City, Iowa, has a little better incentive package. Can you think about that and call us back 11 o'clock in the morning? So sat down with the governor at Cedar Crest that night. We went over it all. Next morning we were ready. Governor did a good job, said, look, if you'll commit to Hutch, we'll find the extra incentive funds. So in the 2009 State Fair, we had the marching band and everybody else celebrating the fact that Hutchinson was going to be the new facility. So I think that we had such a wonderful partnership between the city, the county, the State Department of Commerce, and even the executive branch played a critical role in bringing that facility to Hutchinson. So over the months of negotiations, I think I was on every phone call and every meeting, and not once did I hear someone say to Siemens, look, we'd really like to have those jobs, but we're not much interested in those towers, so we may just put in some setbacks and covenants so you won't be able to sell any of those nacelle units in our state. It's now 2021, and here's where we are today. Siemens, which is now Siemens Gamesa, has brought over 260 excellent paying jobs with outstanding benefits to our community. That beautiful facility, because it's been 10 years, will come onto the tax rolls this year after the 10-year abatement. Enough nacelles have been sold out of that Hutchinson facility to light every home in the state of Kansas and 2 adjoining states. Landowners and local governments in 30 counties in Kansas have enjoyed the economic benefits from wind unit placements, many of them Siemens Gamesa units. So what should you do with Senate Bill 279? Well, just about the hardest thing for legislators to do. Nothing. If enacted, this bill would be the most wind-unfriendly legislation in the entire wind belt. We would have no more new wind harvesting in Kansas. Local governments have both the authority and the knowledge to regulate wind power placements to the extent that it's needed. So even if you try to develop an even-handed bill, and this one is not, the varying conditions, wind conditions, terrain, transmission capability, desires, local desires across the state would ensure that you could not get it right. Please do not advance this bill. And I know you probably don't have time because the president's about to bang the gavel down.
That is correct. We are out of time. The hearing on Senate Bill 279 is closed.